Good morning and welcome to the TPN Credit Bureau YouTube channel. We are going through the HR pack today, some legal training for you. Before we get started, just with me in studio today is Greg Mason, our legal counsel. He's going to be taking us through the eSign platform, the eSign system, simplifying your HR processes for you. To the left of me, as always, Richard. Thank you very much for joining us today. Richard Mayer from Fullard Mayer Morrison is a director at Fullard Mayer Morrison, as well as an acting Labour Court judge. So today we're going to go into some of the legal sides of signing documents electronically. And of course, Jade Matembu also with us in studio today facilitating the session. You can't see her up on screen, but she is hopefully going to be interrupting us while we speak, that we don't just have soliloquies on the law today, but make it a little bit fun for our clients to get involved in their HR processes, as well as all electronic signatures on their HR documents. Before we get going today, please remember just 3 housekeeping rules. You need to be logged into TPN YouTube, or rather YouTube, not TPN YouTube. Hey, are we going to trademark that? But YouTube, to be able to access the chat. You can ask all of your questions directly in that chat box today. Jade's going to be handling that and facilitating those chats. If there are pertinent questions related to the subject matter, related to your HR processes, perhaps related to eSign, she's going to interrupt us and ask those questions during the session. There's also going to be 3 poll questions that go up around about 10, 20, and 30 minutes into the session. Please go and answer those for us. We did not get dressed up. We don't look this dapper for nothing. So if we do seem a little bit blurry on your screen, go and click the cog on the right-hand bottom and go and select 720p or higher so that we are a little bit better in definition. And then lastly, we are going to be running our normal feedback sessions right at the end, our Q&A. Jade will be posting up a feedback form that you must please go and complete for us, not just important for our own feedback, but perhaps go and include things like further training sessions that you'd like for your employment processes. I know we've got a number of different clients online today. We might have some property clients, we might have some schools, we might have just some recruitment agencies, some employers. So we're really going to be speaking about the general side of signing documents electronically, as well as showcasing the changes that we've made with the HR pack so that you can be more comfortable in sending out your documents electronically and having those signed. So what we'll be covering in the session before we get started is electronic signatures and employment agreements, which documents on the HR pack can and cannot be signed electronically, disciplinary processes through video platforms. I think that's a very important one for today that we're going to be covering. Richard will be covering that for us. The Property Practitioners Act and possibly some changes that employers need to make with their processes with their employees, specifically for those in the property sector. How to use eSign. Greg, you're going to take us through a demo on the eSign system, showcasing exactly how to use that system. And then we're going to end off with possible changes to the HR pack, possible changes to the employment scenarios that we are currently facing in South Africa. That seems like a mouthful. You guys haven't even spoken yet, but let me get started with some questions. And please feel free, remember, to go and like and subscribe our pages so that you get updates on every new training session that we go and do. And please remember, we are going to run the session interactively, so keep those questions coming. Richard, first one for you today. Okay, let me put you on the spot. I'm sorry, this feels a little bit interesting having 3 people on the screen today, but we're really going to swap questions between the 2 of you. Greg's going to be taking us through the eSign platform. I'm going to be focusing on some legal questions for Richard. When dealing with electronic signatures, and electronic signatures specifically on employment agreements, what rules do we need to take into consideration? So the Electronic Communications and Transactions Act obviously deals with how to sign documents electronically, what processes to follow. But just speak to us a little bit, Richard, about what documents, specifically employment agreements, can they be signed electronically? So can they be sent to the possible or potential employee, and can you actually sign those employment agreements electronically?
Thank you, Peter. I think it's important to take a couple of steps backwards. And the first point is, in terms of the Basic Conditions of Employment Act, there are 2 important documents that must appear in writing. That is your contract of employment and the notice of termination of employment, either from the employer or the employee side. But in terms of the Electronic Communications and Transactions Act, the requirement that a document must be in writing is satisfied if the document is in the form of a data message, firstly. And secondly, if that data message is accessible in a manner which is usable for subsequent reference. So what that basically means is if you can retrieve the data message subsequently after the event. And then going forward, the Electronic Communications and Transactions Act specifically provides for the fact that if you sign by way of e-signature, that is valid for the signature of employment contracts and in any other commercial documentation. And perhaps just to help the viewers, in terms of e-signature, the Supreme Court of Appeal has explicitly stated that if you have the typewritten names of the parties at the foot of an email, that is good as electronic signature for the purposes of the Electronic Communications and Transactions Act.
Okay, so writing would be a data message. It's not necessarily wet ink writing that we're talking about today. It's actually electronic communication.
Correct. So the classic form of a data message would be your email, but also things like WhatsApps and SMSs.
Okay, interesting. So Greg, Richard touched on the Electronic Communications and Transactions Act. I know we hate using acronyms here. We might refer to as ECTA sometimes during this, perhaps even the Property Practitioners Act as the PPA. We're going to try not to. But with the Electronic Communications and Transactions Act, there are specific rules, guidelines, ways of sending through electronic communications, but also ways of signing documents. Would you just take us through those rules, please, contained in ECTA?
Of course, thank you, Peter. As Richard pointed out, with legislation, unless it's legislated that you cannot sign a document in the form of an electronic signature, it's assumed that you can. So the Electronic Communications and Transactions Act sets out certain items of legislation that prohibit the sending of an electronic signature. Some examples of that, which will be pertinent for our sales agents that are potentially listening at the moment, is the Alienation of Land Act. We also specifically have the Wills Act. So when it comes to an electronic signature, there are three things that are very important to remember for the purposes of signing an electronic signature. And that is that the electronic signature can be authenticated, meaning that both parties that sign, it is actually the party that signed it that has signed that signature. From a TPN perspective, the e-sign platform, we deal with two-factor authentication. So an email is sent out to the email address that is stipulated, as well as a one-time PIN, which is sent to the cell phone number, which is stipulated for that contract. So the party is not in doubt when it comes to the signature of that contract. We also then look at approval between the parties. What this means is that the parties have agreed that the method of electronic signature that is being used is agreed between the parties. This is vital so that there's consensus between the parties. When both parties use the same platform for the purposes of the electronic signature, there is almost an assumption that the parties have agreed to use that platform to conclude their agreement. And finally, the third requirement is that there's a reasonable methodology. As Richard touched upon, it's the ability to, at a later date, be able to recall those signatures that have been completed, and that there's an audit trail that sets out how those signatures were completed. So on the TPN e-sign system, you can go back at any time by logging into esign.tpn.co.za, and you can access the document, which has at the bottom of it those two signatures that have been concluded by the two parties.
Excellent. Thanks, Greg. I think it's important here also to note, if you have not yet utilized the e-sign platform, because we have updated the residential lease agreements, the commercial lease agreements, obviously not the sale contracts, and we'll get into that right now as well. But the HR Pack documents have now been updated for e-sign specifically. If you have not yet had a look at that, you're more than welcome to email the helpdesk at tpn.co.za, or just contact the office line, the 0861 876 000 number. Greg, just getting back to that as well. So when we built this e-sign platform to specifically deal with Section 13 of the Electronic Communications on Transactions Act, because that sets out these rules and guidelines that you've just talked about. We took into consideration what those guidelines are, and those three things that you just specifically mentioned.
Yes.
I think the important one here, and just showcasing that when you go through the demo, is specifically the one-time PINs that we send through.
Absolutely.
And the one-time PINs get sent through. How do they get sent through, Greg?
So they get sent through directly from the system. You'll include the cell phone number for both the parties that are included. So for our purposes today in the demonstration that I'll give later on, we're going to use an employment agreement. So it will first get sent through to an employer. The employer's cell phone number will have been listed. An email will first be sent to the employer, including a link to a document. You click on open up the document, and then at that point, a one-time PIN is sent from the TPN's e-sign system to the cell phone number of the employer. They can then take that one-time PIN and put it back into the system to verify that it is them that is signing the agreement.
Greg, I know when you practiced to do the training yesterday, we saw that the one-time PINs last for a certain period of time. So I think it's an important thing just to showcase how long do those one-time PINs last?
Absolutely. So you have 24 hours from the time that one-time PIN is sent through to then input that one-time PIN into the system.
Excellent, thank you. Dealing a little bit more with the law here, with regards to our updates on residential and commercial lease pack as well as the HR pack, we're allowed to do so in terms of the Electronic Communications and Transactions Act. But you touched on two different portions or two pieces of legislation that cannot be signed electronically. Will you please take us through that?
Absolutely. So most importantly for our sales property practitioners, the Alienation of Land Act specifies that the agreement must be concluded by way of handwritten signature. So an electronic signature, which is set out at Section 13 of the Electronic Communications and Transactions Act, will not be applicable to the signature of a sales agreement, specifically for the sale of an immovable property. Additionally, the Wills Act, for the purposes of a last will and testament, you also cannot conclude that by way of an electronic signature.
So there's obviously specific formalities attached to the Wills Act and specifically sale documents as well.
Yes.
So please don't go and sign electronic sales documents at the moment. I know there was a possibility of perhaps doing so later on, but we will obviously update you once there is a, let's call it perhaps a court decision, perhaps even a change to the legislation as a result of that. Thank you, Greg. Richard, having briefly spoken about employment agreements and employment agreements being, or you being able to sign employment agreements by way of electronic signature, may other HR documents also be signed electronically? Say, for example, disciplinary processes, probationary processes, etc.
Correct, Peter. Obviously, if you can sign an employment contract by way of e-signature, all the other documents in the HR pack are capable of being signed by electronic signature. So as you say, disciplinary proceedings, retrenchment letters, consultation process and a retrenchment process, warnings, leave forms, leave applications and the like. So all of those are capable of being signed by e-signature.
Excellent. I'm sure there are currently, obviously, or not currently, let's say over the last 2 years, because of the working from home scenarios, I'm sure there's been a lot of employers sending through specific notices, etc., electronically. But what I think is important to note over here is some of those notes, or rather the notices that have been sent out, is possibly not dealing with Section 13 of the Electronic Communications and Transactions Act, just like what Greg said. So, Richard, just breaking it down a little bit further, say, for example, a disciplinary process, warning letters, etc., those can all be sent through electronically and signed.
Correct.
Okay, that's great news, because it does cut down, obviously, on Save the Pandas and not printing out paper-based documents, but it does create specifically through the e-sign platform, it does create that repository so that you can go back and see exactly what documents have been signed, what documents have been sent through, perhaps on your warnings, etc., suspension notices, all of those. Then there is some form of back end that actually saves the documents for you
and a record.
And a record, okay, which is very important. I'm sure this is one of those that a lot of clients want to hear about today, and that is specifically disciplinary and other processes such as hearings taking place in electronic format through different, let's call it video conferencing platforms like Zoom, Microsoft Teams, etc. There must be certain rules attached to this when you think about it, because I mean, usually with disciplinary processes, you're sitting across the table from somebody, you're discussing it, specifically the hearings. Can these actually take place through video conferencing platforms, Rich?
So Peter, you were talking about sitting across the table. I must say I'm an old school guy. I like the eyeball to eyeball type of scenario, but certainly the trend has been in the last 2 years, particularly under COVID, that the shift has been to video conferencing across the board. So you're getting it at court. That is the default now, is video conferencing. You actually have to apply in certain cases to have a physical hearing. So across the board, video conferencing is the way. And the tone was set by a case which was at the height of COVID, where there was a retrenchment consultation process between FAWU, the South African Food and Allied Workers Union, and SAB. And it was a retrenchment consultation process which FAWU then tried to interdict and prevent by an urgent application to court, stating that if it was going to be done on a video conferencing platform that was occurring at the instance of SAB, the employer, this would be procedurally unfair. They said it would only be procedurally fair if it occurred on a face-to-face physical basis. And the court rejected that application and said that COVID had set a new normal where such video conferencing facilities could be used for such consultations. And there isn't a lot of authority on the disciplinary process to come to a disciplinary scenario. And I think it's because it's become such an accepted part of practice that video conferencing is an acceptable means to conduct disciplinary proceedings in appropriate circumstances. And I think that's the important point, in appropriate circumstances. So a chairperson of a disciplinary proceeding who is hearing it by way of video conferencing would have to be careful to ensure that there is fairness, particularly to the employee who is subject to the disciplinary proceedings. And I think two factors which would be very important would be, is the employee comfortable with the process? Are they able to operate the platforms adequately to mount a proper defense to the charges that are raised? And secondly, the leading of evidence.
Yes.
So if there's difficulty leading evidence in terms of obtaining witnesses who can give evidence online, on the platform, that would be one factor which the chairperson might decide means that the hearing must take place physically. And then, of course, the leading of documentary evidence. There might be problems doing that on the part of the employee, so that could also mean that the proceedings could be considered procedurally unfair if there was difficulties with that. And I think another important part of the process, which we all have experienced at times, is connectivity.
Yes.
If connectivity is a problem and it starts disrupting the hearing, a decision might have to be made that we might have to revert back to the old school physical hearing, where one can be in one another's presence, one can hear what is being said, and have the documentation, witnesses presented in everyone's presence in a physical face-to-face environment. And obviously connectivity could be a factor which disrupts both the procedural fairness of the process and sometimes even the substantive fairness, in the sense that the outcome of the hearing could actually be unfair, not only from a procedural point of view, but on the correctness of the decision, simply because some of the evidence was obscured and the chairperson makes a decision on the basis of evidence which wasn't properly presented, or he didn't come to his attention because of the connectivity issues.
Yes. This is the thing we discuss very often, me and you, is procedural fairness when it comes to these hearings. So I think a very important takeaway point from that is that when you are performing these processes electronically through the video conferencing platforms, that you ensure that it is a viable option for both the employer and the employee to participate freely and voluntarily, as you would have when you're sitting across a boardroom from one another, and perhaps leading witnesses, leading evidence, and granting that party the aspect of procedural fairness to ensure that the hearing at the end of the day doesn't end up at the CCMA.
Correct,
Okay.
Absolutely.
Great. Jade, do you have any questions for us? Perhaps some poll feedback?
I I do have a question, Peter. You have a question from Diana. She'd like to know, has the updated HR Pack taken into account the Property Practitioners Act for the following: employment of staff and appointment of consultants who are involved in marketing, sales, and letting?
That's a great question, Greg. We were actually leading up to this question in the next one. We will obviously deal a lot more with the property practitioners in the next section, but I think it's important that we do answer that question. Employment agreements specifically don't need to be amended for the Property Practitioners Act.
That's correct. So one aspect that is important that is amended and has been updated in the packs is with regards to Fidelity Fund certificates. So the changes with the Property Practitioners Act now require that admin staff in your office that are involved in the day-to-day operations of the business also have a Fidelity Fund certificate and be registered as a property practitioner. From a company perspective, you also need to have a BEE certificate. For the smaller enterprises, you can obtain the affidavit, which stands in as your BEE certificate. And then on an individual level, as well as on a business level, there also needs to be a tax clearance certificate from SARS. So these requirements that have been brought in with the new Property Practitioners Act have been updated in our
Yes.
packs.
But I mean, anyway, from an employment perspective, if you were an employer for specifically an estate agent, let's call it that, prior to the Property Practitioners Act coming into play, your estate agents anyway needed to have Fidelity Fund certificates. There's just new requirements attached to those Fidelity Fund certificates, if you may.
That's correct. So they've just been updated slightly rather than taken away or anything else.
Excellent. Thanks, Greg. Jade, anything further?
So I have just ended my first poll, or our first poll. How many staff members does your organization employ? Out of 83 votes, 64% voted 1 to 10 staff members, 23% voted 11 to 50, and 13% voted 50 and more.
50 and more. Thank you. So we do have the SNNEs today online, as you can see. So we're really going to try and simplify this process for you when Greg does go through the eSign platform. Greg, the question from Jade actually really led me into the next question. So I think just as a sort of breakdown, what is required from an employer's perspective, looking at the employees specifically as a property practitioner? What do they need to get in place at this point in time? What do they need to focus on?
So your focus at the moment should be making sure that all of the staff that you have in your offices are registered as property practitioners and have their Fidelity Fund certificates in place. As I touched on, this will include getting a BEE certificate and include obtaining tax clearance certificates, but thereafter the obtaining of those Fidelity Fund certificates from the Property Practitioners Regulatory Authority will be your primary focus with the change in legislation. In addition to that, from a company perspective, once you have your Fidelity Fund certificate, that Fidelity Fund certificate must be available to be seen by any member of the outside public. So if I walk into any property practitioner's office, your Fidelity Fund certificate should be displayed, and if I request it, you should have it available for me to be able to see.
So just going further into that, we haven't updated the employment HR agreements to reflect anything of the sorts at the end of the day, because I mean, it's a process-based that you need to go and follow with the people that you employ at the property practitioner. But from a residential side, there have obviously been clauses amended to our lease agreements, commercial lease pack, as well as the residential lease pack, things like warrantying the validity of the property practitioner's Fidelity Fund certificate at date of signature of the agreement.
That's correct, yes.
Okay. Starts to make a lot of sense then. So with the employment contracts, no, not necessarily changes that need to be made, but with the other documentation packs, we have already done so.
Absolutely, yes.
Thanks, Greg. Greg, let's simplify this process. I'm sure there's a lot of our clients out there today wanting to start with their HR processes and ensuring that these processes are done correctly through an electronic signature tool. So if you wouldn't mind just taking us through a 5-minute demo, 10-minute demo, 15-minute demo, I really don't mind, you go for it, and just showcase how eSign works and how to get those documents to send through to potential employees.
Perfect, thank you. Okay, so as a starting point for where to access this information is on the TPN shop. So you can log into shop.tpn.co.za. If you've already purchased the HR pack, you can click on the My Documents tab and you can then enter the HR pack. Once you're in the pack, you'll see here, previously you would download a Microsoft Word version or a PDF version of the document, and you'd be able to fill it out with a pen, and it would be concluded in that manner. But now you have the availability to complete it by e-sign. Once you click on this link for e-sign, it will then generate a contract which can be used. In this contract, you'll be brought to this page. From this page, you can then start including details of the agreement. Just for the purposes of today, I will be the employer, and I'm employing someone by the name of Joe Soap. So I can conclude that my agreement of employment is with Mr. Joe Soap. I can then proceed. At this point here, I will then include the information of the parties that are going to be concluding the agreement. So I will do it on behalf of the employer. And you'll include your email address.
I hope that's not your correct cell phone number. Greg.
That is not. And then from an employee perspective, you will also conclude Joe Soap. You will include Joe Soap's cell phone number and his email address. At this point, you will then save the information. So that would be incorrect. It would be Joe. You'll save that information. And at that point, you'll conclude, and it will generate onto the document. You'll then be presented with a contract that you're going to be completing. In this case, we have an employment agreement. On this page, you can then fill in all of the information that's going to be included into your contract. This will be your employer's details, your employee's details, bank accounts for your employee, the details of the position that the employee is being hired for, working hours, payment, the salaries, and anything else that's going to be included into that contract. Once you have got that information input, you can then proceed to the next step. It's important to know that once you proceed to the next step, the document will be then locked for editing. So you can't run the risk that you send out an agreement, it's going to be edited without your knowledge and sent back to you. You'll confirm that everything has been included in the document, and you'll move on to the next step. So now you have your completed HR employment agreement, but it will be unsigned. Once you're here, you will then send the document. You'll click on Send Document, and you'll receive an email. This email will then come to, so the signatures will be staggered. So you'll first be sent to the employer. Once the employer has completed the electronic signature, it will then be sent to the employee to sign. So I will do this from the employer's perspective, and I'll talk you through what would happen with the employee. So I, at this point, will click on Open Document. Once I click on Open Document, I will be sent a one-time PIN, and that one-time PIN will then allow me to enter in here and will validate that, that I am the person that is meant to be signing the document. As we touched on earlier, it's important that we are able to authenticate that the people are who they say they are. So now through my email address and through my cell phone number, I am able to confirm that this is in fact me that is signing the document as the employer. The document will be generated again. In this situation, everything will be filled out already. Everything will have been done. I will go down towards the bottom of the document after I've read through all of the provisions and made sure they're all correct. And now I have the option to sign the document. Once I click Sign, I can input my name, which has already been done, and the electronic signature with a unique e-sign verification will be included on the document. I then click Sign. Once that signature has been processed, I as an employer have completed my side of signing this employment agreement. At this point, an email is then sent to the employee, which states that the document has been signed. An example here is that this will then change to signed by the employee. Refresh. You would need to re-log in. And I've now chose that I have signed the document as the employer on today's date. Now you can see here that the employee is awaiting signature. The employee then will receive the email. They will go through the one-time PIN process. They will go through the signature process that I've pointed out. And once they have signed, you will see here both parties have signed the document. You now have a valid and binding employment agreement. You at that stage can then go and view the document and you can collect it at a later date. So the e-sign system really is as simple as a couple of clicks of a button and verification with your cell phone.
Excellent, Greg. Thank you so much. That really does simplify your HR processes for you. And that works exactly the same with your employment agreements, as well as any notices we talked about with Richard as well.
Correct. Anything that needs to be signed, other than the exceptions that we spoke about earlier, can be done through the system.
Thanks. I know Greg ran through the session quite quickly when it came to the electronic signature platform. There is a video that we posted up when we launched eSign for the residential and the commercial sectors. If you'd like to go and access that, that is directly available off the YouTube channel, and we take you through about, I think it was a 45-minute training session on eSign specifically. But this is really just a showcase on how to utilize and how really simple it is to go and use those documents. Now, Greg, like you said, we talked a lot about the law. We said those 3 rigid guidelines for signing documents in terms of Section 13 of the Electronic Communications and Transactions Act: dual factor authentication, inputting your OTPs, ensuring that the documents have been signed, they're utilizing the same process, they hopefully reading the terms and conditions, but actually just clicking that they're accepting the terms and conditions, like we do with our cell phone contracts. All of us go and read your terms and conditions. But those 3 rigid guidelines are processed directly through the eSign platform.
Absolutely. The platform has taken those specific legislated items into account.
And then off that last screen that you showed, that repository screen, you can obviously go and access the documents again after some period of time and go and print those out, correct?
Exactly, you can.
Wow, okay. Well, it really does make that HR process simple, hey?
It does. And you also have the ability from that screen, once you view the document, you can save it as a PDF to your own computer. That way it's not, you have an ability to back up the information as well.
Excellent. Thanks, Greg. Jade, do we have any further questions? Perhaps poll feedback?
We have some questions, Peter. I have a question from Alicia. Do individuals need tax clearance and BEE certificates as natural persons to apply at the property practitioner's regulatory authority for their fidelity fund certificates?
Greg, would you handle that one for us, please?
Of course. So is this from the perspective of an individual who's operating their property practitioner's business?
Correct, yes.
Yes. So that individual will have to have the tax clearance certificate previously to obtaining their fidelity fund certificate. And additionally, they could complete the BEE affidavit, which sets out, which stands in as a BEE certificate, as they are essentially running their own small business as themselves.
Just a one note from my side. Obviously, the Act speaks about a business property practitioner,
Yes.
as well as an individual property practitioner. So as a business property practitioner, PTY Limited, closed corporation, perhaps even a sole prop, you would need to have that BEE certificate. But from an individual capacity, from a property practitioner's capacity, you obviously can't have one.
Of course. So
Yes.
it's mainly for the purposes of you running it as your own business.
Okay, great. Thanks, Greg.
Okay. I just have 2 quick questions dealing specifically with eSign. A question from Julia. Does eSign allow only the document that is in the TPN HR pack to be used with eSign, or can you have your own document that could be converted to eSign?
I will handle this one. At the moment in time, the residential, commercial, and your HR pack documents have been loaded to eSign. The system only allows you to complete our documents, so all of those HR documents, the residential lease pack and the commercial lease pack documentation. I am not sure what they're planning in the future. Perhaps it's possible that the developers will go and create a rule that you could create your own documents, perhaps even through the DocPack system, to load through onto eSign. But the current functionality is only the residential, commercial, and HR packs that are available to the subscribers of those packs. And remember, even if you are a Word subscriber to the pack, this use of this platform is completely for free. Hey, it's not that you need to pay for the eSign platform. So as a Word subscriber to any of the documentation packs, you can currently go and use that. We might have a look at it later. I'm sure they're looking at that, but for the moment, it's only the documentation that you have as a subscriber to those 3 different packs that is available through the platform.
Okay, thank you. And then I have a question from Annalise. Can the terms of the employment contract be updated by the employer prior to sending to the employee?
Greg, I think that's a question to you, but you did showcase that on the...
Yes, so specifically the schedule to the document. So that will be the information that is included in terms of who the employer is, who the employee is, anything relating to operating hours and salaries. Those can all be amended prior to sending, but I believe the actual terms of the employment agreement at this stage, no.
So the schedule with all of the different packs are sort of the variable terms that often differ from contract to contract. But the terms and conditions are very boilerplate when it comes to residential lease agreements.
Exactly.
Commercial. So the T's and C's, as you know, TPN's got a very specific format with the documents. You've got your table of contents page, your schedule page dealing with the variable terms like Greg mentioned, and then your terms and conditions. The schedule is editable and variable on the contracts.
Correct, and as we pointed out previously, once you have completed filling out that information, you'll obtain all of the employee's information, and you'll input it into that contract. And once you generate that document, it then can't be amended again later, to avoid that risk of potentially something coming back, being changed, and you're not realizing it.
That has happened many a time with sending through on emails. You can only imagine with amended PDFs or amended Word documents, it does happen. So eSign actually protects you against that.
Exactly.
Great, thanks Greg. Jade, anything further?
Yes, so I think we should discuss some poll results. Our second poll went up, and the question was, have you implemented a formal return to office policy in terms of COVID? Out of 73 votes, we got 29% of our delegates saying yes, 58% of our delegates saying no, they have not, and 14% of our delegates are planning to do so.
Thank you very much, Jade. Richard, finally, before we head into the informal Q&A session for today, there's been so much happening in the HR scene over the last 2 years, ranging from changing leadership styles, mandatory vaccination policies, working from home, and different policies related to that. Jade just mentioned a return to work policy that is created for employees returning to work. Not to put you on the spot here, but what do you think the major changes are going to be looking at HR employment throughout this year? What can we expect in the employment sector for the year?
So Peter, I think the hot topic of the moment is obviously the mandatory vaccination policies and their implementation. And I think the principle is that mandatory vaccination policies are valid. The devil is in the detail. So we're looking for guidance. There have been cases at the CCMA which have shown some sympathy for employers who implement mandatory vaccination policies, provided that they comply with the requirements that have been set by the Department of Employment and Labour with regard to a risk assessment with regard to COVID in the workplace, and the implementation in a procedural manner of a mandatory vaccination policy. So there's sympathy, but obviously each case is separate and different. And so we're looking for guidance when those cases go to the Labour Court, possibly on review, and then to the Labour Appeal Court. And I've no doubt that a case will eventually reach the Constitutional Court. And I don't think we'll get a yes or no answer. We'll get guidelines on what principles will apply and how the mandatory vaccination policy should be implemented. And I think obviously the two poles would be where an employee has a legitimate health concern in refusing to be vaccinated. And then the courts and CCMA, the bargaining councils, would be very, very sympathetic to that employee, and the employer should tread very, very carefully in those circumstances. And then, of course, you get the other side of the coin, the employee who appears just to be obstructive and not having particularly strong reasons. And then, the employer can maybe take stronger measures. So ultimately, if my guidance to employees and employers in such a circumstance is, if your employer, try and accommodate your employee as far as possible. And if you are an employee who objects to mandatory vaccination, you must have good reasons and not just be obstructive.
I think it's quite an interesting thing over here. We might seem very strict when it comes to this mandatory vaccination policies in South Africa, but I've read or listened to so many podcasts on differing countries when it comes to these mandatory vaccination policies. I mean, in Canada and Quebec at this moment in time, you actually need to have a vaccine to go and do shopping, to go into a supermarket, to go and do so. So I think it is a very viable thing that you're talking about today, is that there needs to be procedural fairness as well, just like with e-sign and with your electronic documentation, that there needs to be procedural fairness.
Correct, absolutely. So procedures, everything in this circumstance. So if an employer can show they've really done everything to accommodate an employee who, with good reason or less good reason, refuses to vaccinate, if you've really shown that you've done everything possible from a procedural point of view to accommodate that employee, and dismissal is absolutely a last resort, you'll probably be okay. But I think one must obviously be cautious and be careful and not rush to dismiss or discipline too hastily. And then just going forward, you're talking about return to work. I think from a legal but also from just a business point of view, I think the balance to be struck by employers in this regard is that sense of esprit de corps that you get from being at work. I must say, I like being with my colleagues, having them in the next office, going having a cup of coffee with them, chatting in the kitchen, or just discussing matters on a face-to-face basis, putting my head at the door in their office. But of course, there are great efficiencies and savings if people do work from home. You know, if people avoid a 1 to 2 hour commute to and from work, that is a great saving, which could be put into more productivity. And of course, if you don't have a lot of people in the office, you have less need for office space, you can rotate people. That also causes cost reductions and greater efficiencies. So there is a balance to be struck, and I think we're going to find ourselves in a hybrid system. Instead of having face-to-face meetings like we have Zoom and Teams meetings, you'll also have maybe some companies allowing some presence at the office, but also people working from home on a greater basis than happened before COVID.
Yes.
So there's that.
I hope that's true, because the N1 is stacked at the moment when I come to work. So
The highways are becoming busier as people return to work. And then on a slightly tongue-in-cheek level, Peter, just to answer your question, there's much talk of the fourth industrial revolution. There's so much going online and digital, and the implementation of artificial intelligence in the workplace. A lot of jobs are being lost because routine tasks that can be performed by people in the past can now be performed by computers and artificial intelligence. And just without wanting to sound like I'm protecting my own field, I do feel there's some time yet, if at all, in our lifetimes, that artificial intelligence will replace people like chairpersons of disciplinary inquiries, arbitrators at the CCMA or the bargaining councils, or labour court judges. So we watch this space, and we watch the advance of the fourth industrial revolution and AI.
well, I most certainly, if I purchase a property or if I'm renting a property, I want a physical property practitioner there rather than anybody else doing my inspection. So thank you very much for that, Rich. That brings us to an end of our formal discussion today. Jade, I'm sure you've got a lot of questions, as well as that last poll feedback. If you would run through those for us right now, that would be great.
No problem. I'm going to post the feedback form in a minute. I have a question from Retha Botha and from Goss Property that's very similar. They'd like to know, and they want clarity on this because they're saying it's causing a lot of confusion. Do all admin people in the office need FFC certificates as well? Feels like this is a very grey area.
It is. Greg, I mean, we've had a look at the definition of property practitioner over the last 2 months. It has been broadened so much that you can read a lot into it, can't you? I mean, you can read, and there's been different opinion pieces regarding developers and developer staff that actually need to be registered. Jade, it is such a difficult question to answer with 100% clarity. What Greg and I and you have been doing over the last 2 months when we advise clients on this is to contact the Property Practitioners Regulatory Authority for those specific staff that might need to be registered or have their Fidelity Fund certificates. There's a section included that you spoke about that said any person that deals with the day-to-day management and supervision and administration should be registered. But 100% most certainly in terms of Section 4, you can apply for certain exemptions in terms of the Act to perhaps exclude certain employees, exclude certain people that don't directly deal with clients perhaps, and I think that's an important note to make. we would love to give you like a completely clear, distinct answer on something like this, but we are not the authority. So it would be one of those questions that I unfortunately do answer with, please go and have a look with the Property Practitioners Regulatory Authority if those specific people need to be registered.
Thank you. I have a question from Renzi. Please confirm the status of canvassers not working directly from the Property Practitioner's office, but working from their home office.
That's a great question. Do you want to handle that one for us?
So this, in a similar sort of sense, if it's involved in the day-to-day operations of the business and they are working directly for a property practitioner, the Act seems to state that they would also need to be registered as a property practitioner and have their own certificate. But again, we're in a bit of a transitional period at the moment, and we are still awaiting 100% clear-cut guidelines on exactly who will need to be registered. So again, as an individual, you can go and approach the Property Practitioners Regulatory Authority. You can request guidance on that specific employee, and you can obtain your answer.
I think it's important there also, if you get remuneration or commission for the sale of a rental, sale or a rental of a property, it's very possible that that person would fall into the definition of property practitioner, even if it's just for canvassing.
Okay, thank you. Question from Karine. This is in relation to e-sign and the lease agreement. Can the landlord sign before the tenant, or must it be signed in a specific order?
So with regards to a lease agreement, they say.
Yes.
So in terms of that, we would recommend that it would be first signed by the landlord and then it given to the tenant as a full offer of what exactly they're going to be leasing. And then once that tenant has signed that document, it is then a valid and binding agreement. So yes, we have the orders.
I think that's an important one. That there's obviously process 100% still to be followed with residential leases. Even if it's not like a sale of a property. Exactly. But if the landlord does sign first, it creates that offer, and then you have that offer and acceptance through e-sign. So great, yeah, good answer, Greg. I think that offer and acceptance is vitally important.
Okay, Larishka would like to know, do we also now add the mandatory disclosure form for rentals?
The mandatory disclosure form for rentals.
We're dealing with a lot of things today.
Got a lot of property practitioners on today.
Yes, so for property practitioners, that mandatory disclosure form is now something that must be included with all leases that are concluded after the 1st of February, as well as the renewals to agreements that are going forward after the 1st of February as well. So that mandatory disclosure form is included in our residential lease pack, as well as in our commercial lease pack, as well as in our sales pack. So it is available there in the packs on shop.tpn.co.za.
Greg, and that mandatory disclosure form, it must be signed obviously before the mandate agreement is concluded between the parties, but also attached.
That's correct. So it's going to be signed by the landlord or the seller, and then once that has been concluded, it will need to form an annexure to the actual final agreement that is concluded.
Okay, I have a question from Rowan. Can a property practitioner refuse to sign an employment contract, even if the principal is willing to make changes?
So
sure, a person can do anything about the consequences.
You can obviously negotiate, but if you're going to conclude, if you want to have a business working relationship between an employer and an employee, it is imperative that you have a signed agreement in place between the two. As Richard pointed out, it must be in writing. So yes, you should have a signed employment agreement of sorts.
Okay, another question from Diana. Does your HR pack have a mandatory vaccination policy?
Yes, it does. So we do have one that's in the pack. It can be downloaded, and if you want to make amendments that it's specific to your business, you can also do that. With
that was obviously drafted by Richard right over here.
Yes.
Okay, Richard, I think this question I can give to you. A question from Liba. When it comes to mandatory vaccination, is fear a fair reason if an employee has experienced 2 deaths in their family after the members got vaccinated? They're just asking, is it a fair reason? So would you like to weigh in?
It's obviously any legitimate reason why the employee does not want to be vaccinated can be raised. Quite where that goes is another matter. So there is extensive requirements for counselling, and perhaps the fear could be analysed and subjected to counselling, and an outcome could possibly be reached where the fear is overcome, or if the fear remains, the employer and the employee will have to try and find an accommodation. And of course, I mean, it's not a black and white issue. There's so many ways in which the employer and the employee can find each other, such as trying to accommodate the employee's legitimate concerns, fears, and if the mandatory vaccination will not go ahead, accommodate that employee by allowing that employee to either work from home, if possible, or work in his or her own office and wear masks in the workplace. So it certainly would be a legitimate concern that the employee can raise, but quite where it goes would have to be part of that procedural process that Peter and I have discussed.
Thank you, Richard. Question from Graham Cox. Are there any exceptions that can be applied to the BEE certificate requirements for a property practitioner? Are we aware of any?
No, there are none. There's only an exception when it comes to the auditing of a trust account in terms of Section 23, Greg, if I'm correct on this, that states that you can basically apply for exemption of auditing of your trust account if you fall under the annual turnover of 2.5 million.
That's correct.
But from a BEE and certification perspective, there is no exception in terms of the legislation.
Okay, thank you. Question from Tabo. Does the HR Pack cover the property practitioners who may wish to be treated as independent contractors?
Absolutely. So we have a variety of contracts that are in the HR Pack. They range from the normal employment agreement to fixed term agreements. We have a commission-only agreement, and we can account for those commission versus commission and basic structures. And we also do have an independent contractor agreement that is in the HR Pack for those that are independent contractors.
Greg, just another note on that, Richard, and I hope you don't mind me throwing you into the fire here over there. But I think there is obviously sometimes a lot of difficulty in determining whether a person is an independent contractor versus a full-time employee of a business. Perhaps just speak to us a little bit about that.
Yeah, it can be a grey area. I think your classic independent contractor that we would encounter in our day-to-day life would be your plumber or your electrician. They come and do a job for you, and they're not economically dependent on you. The difficulty with having an independent contractor agreement is that you could find yourself in a position that in reality and substance you are an employee. Despite what you say in the independent contractor agreement. But it would depend to some extent on economic dependence. So if that independent contractor actually is not receiving the bulk of his income from being of service to or acting as a property practitioner, then the emphasis would be towards the independent contractor relationship. So if there's economic dependence, on the other hand, the emphasis would be towards an employee relationship. So it can be a grey area in certain ways, but if the person is getting, let's say, only 10% of their earnings from working as a property practitioner, the emphasis would be to being an independent contractor, but if more than 50% of earnings are coming from being a property practitioner, you'd be an employee, whatever the form of the contract that would be.
I think that's an important sort of segue, is checking with a labour attorney before you enter into independent contractor agreements, thinking that they're independent contractor agreements rather than the employment agreements, because you could be left with a scenario that you think it's an independent contractor, but it's actually an employee.
Correct.
Thank you. I have a question from Pitsy Baloy. Is the signature, and this is in regard to e-sign, is the signature automatically created after you put in your names, or do I have to create it myself?
So you will input your name onto the system on the signature page, and it will create a signature for you. The actual the actual thing that looks like a signature, that alone is just a visual aid. What is the actual signature is the item in the system that sets out that unique identifier. So the visual representation of what a signature would look like if you put pen to paper is therefore a visual aid, but the actual signature is more contained within the system itself. So that will be automatically generated for you.
Thank you. And then I have a question from Karen Dunlop, and we've actually been asked for clarity on this question. For sole proprietorship that falls under the threshold of income and thus qualifies for exemption of BEE, is only an affidavit required, and where do we send that affidavit?
Oh, I love these difficult questions on a Wednesday. The difficulty with this is that in terms of the legislation, it says the words a valid BEE certificate. Now, a valid BEE certificate, and we've had so many discussions with this. We had a few webinars actually on this topic where I was asked to speak on this. The difficulty with that is the interpretation of a valid BEE certificate. So the only answer that I can give you there, and I wish I could give you further directive on this, but it's also not a bad thing saying I don't know, is that you need to go and have a look, and you need to check this out with the regulatory authority, with the property practitioner's regulatory authority, because we can only read the law. We can only say that it says a valid BEE certificate. So I would suggest checking with the property practitioner's regulatory authority. You're going to have until the 31st of October of this year anyway to go and complete or get your valid BEE certificates, or even your affidavit if that is the requirement. But I would email them continually and attempt to get an answer regarding what is constituted as a valid BEE certificate, specifically if you fall under those thresholds that are required for BEE.
Thank you. Lastly, from my side, I'd just like to discuss our last poll. Did the new Property Practitioners Act impact your HR requirements? Out of 95 votes, 45% of our delegates voted yes, and 55% of our delegates voted no.
Thank you very much, Jade. That brings us to a close, gentlemen. Thank you very much. Thank you very much, Jade, for assisting us today with the facilitation. Just a couple of things. Thank you very much for joining us today. Hope you enjoyed the session. We are obviously running a couple of sessions next week as well, so please have a look out for those. Remember to like and subscribe all of our various social media pages and platforms. Fill out your feedback forms. That link is in the chat at the moment, so go and complete those for us. And thank you very much once again, everybody. Have a fantastic day further, and see you soon.